We are just starting in 5 to 7 minutes. The resource person is having some difficulties at her place with internet due to the monsoons.
Hello, Gaurav sir.
A very good afternoon, ma'am. Am I audible to you?
Yes, you are. I hope the same is for my side. The audio is clear.
You are audible, ma'am, and visible as well. Today, on the 7th day of the 15 days online refresher course on teaching pedagogy in legal studies, commerce, and social sciences. This program is organized by Barkatullah University, Bhopal, through its Department of Legal Studies and Research. Droid Penal Group, a unit of ADGMS Allahabad, Prayagraj, in collaboration with Guru Angad Dev Teaching Learning Center, a prime center of the Pandit Madan Mohan Malviya National Mission on Teachers and Teaching, Ministry of Education, Government of India. Today, on the 7th day, I would like to introduce our first resource person for the day, Dr. Apurva Dikshit, Faculty of Law, Jagran Lake City University, Bhopal. Ma'am will be taking up a topic which will be different methods of ADR in teaching. So a very warm welcome to you, ma'am, and over to you.
Thank you so much, Gaurav sir, for the introduction. I'll be allowed to share my screen, I believe.
Yes, ma'am, we have been given you the access.
Okay. Is the screen visible now?
Yes, ma'am, completely.
All right. Okay. A very warm good afternoon to everybody present here. First of all, I'd like to thank the organizers for providing this opportunity. It's always good to interact, and it's always good to have these kind of brainstorming sessions wherein us academicians can develop our insights towards the recent trends of our legal education. And the topic which I'll be speaking about today is the different methods of ADR teaching. Now, before we begin to the process and mechanism, I'll quickly highlight how does clinical papers have been evolved, and because clinical papers happen to be one of the brighter, bigger umbrella under which ADR is one of the part. So clinical legal education is something which is essentially a multidisciplined, multi-purpose education which can develop the human resources. And idealism needed to strengthen the legal system. A lawyer, a product of such education would be able to contribute to national development and social change in much more constructive manner. Now, whenever we will read about all these concepts, we will see that clinical legal education is the practical aspect of learning. I mean, whenever we talk about, see, academics and any kind of study cannot be done in a closed room. And I hope everybody over here would be agreeing with me on that. So clinical legal education is a multidiscipline, multifaceted purpose of education through which a student can learn and analyze the various aspects which are being taught to him in a theoretical environment and through theoretical modes. Now, what could be when there's a very basic question when any person would be asking, then why is clinical legal education even required? What would be the benefits? Now, this approach is going to help us in understanding the practicality of the subject, right? Whenever I talk about, for example, if a sales student is being taught something, if he's not told the practical aspects of it. So when we talk about ADR, we have to keep in mind the bigger umbrella, as I said, the clinical paper legal education. Now, under this clinical legal education, when we talk about the benefits, practical approach is the main and the most important benefit of providing students, law students specifically, this practical approach. Now, the second is the student motivation and development. I mean, yes, we have classrooms. Yes, we have lecture based system. We teach them through PPTs and everything. But one cannot learn in a closed room till the time they do not understand the practical and let's say the real life cases. Now, through this, the benefit of clinical legal education is that it helps in the development of the students, and it also motivates them to understand, okay, if there's a real based situation which they're given and they're able to understand, and through that mechanism, they'll also be able to solve the entire situation. Now, another benefit over there is that acquisition of skills. How acquisition of skills happens that, for example, when we talk about the real life situation being given, students would be trying to resolve them through their first-hand approaches, as in they will be applying their own brains and their own skill sets to resolve the issue or to address the problem. Now, in that, they are acquiring a new skill set. Now, when we say acquiring a new skill set, because maybe a person who is just reading through books and maybe analyzing through the concepts and theories might not be able to actually apply the same set of theory in a real life sense. But when we talk about the clinical legal education, the practical part of it, it helps in the acquiring of the new skill set to the student. Now, another ambit is that when we talk about, let's just say, internship, why do we send our students to internship? Because they need to understand the professional ethics as well and the code of conduct. Now, in that aspect, the professional ethics and responsibility is something which is learned through this umbrella and this ambit. Another is that there's an involvement with the local community. Now, when we talk about the involvement with local community, it's a very broad concept. People, for example, through the way of clinical legal education, they're able to contact and come into interaction with a lot of people who are actually facing the problems or who are actually working on the ground. So all these 5 points, let it be practical approach, student motivation and development, acquisition of skills, professional ethics responsibility and involvement with local community is, excuse me, is going to help the holistic and the overall development of a student's mind in order to understand the approach. Now, when we talk about the clinical legal education, the rules of legal education 2008 and the BCI made it a mandate. Like the part 4 of the rules of legal education talk about the standards and degrees in law, and under as in for what the purpose of enrollment as an advocate and inspection of universities, there are certain rules and guidelines which are being mentioned under this ambit, and through that only the purpose, the BCI has actually specified that for the regular courses, either in 3 years university stream or under the integrated double degree stream, students will have to take not less than 28 papers, that is in total, and out of which 18 should be compulsory papers and 4 should be clinical papers. Now, under the paper 1 to 24, is talking about the ambit of clinical papers. Now, when we talk about ADR, paper number 23 is specifically targeted over the outline of the course. When we take a closer look, what are the ambits of paper 23? Broadly, negotiation skills to be learned with stimulated programs, conciliation skills, arbitration law, and practice including international and arbitration rules. Excuse me. Now, in the 2020 as well, there has been a corrigendum through which mediation was also brought to the, specifically mediation was brought as a compulsory subject, which is to be provided to law students, both in 3 years and 5 years by the concerned university and law departments. Now, this has been a very welcome change. I hope and I understand that I agree. I think everybody would agree that studying, or let's just say the approach of ADR, is something which is the need of the hour. And that is required by everybody at every stage. Moving ahead. So moving ahead, there are certain statutory laws which have been supportive of this clinical legal education. And when I talk about clinical legal education, now the entire agenda and the focus of this session would be on ADR. So these are the set of laws which have been focusing primarily on the support of ADR as a mechanism. Let it be the main and the most foremost important legislation is that Arbitration Conciliation Act 1996. Another is Industrial Dispute Act 1947. Now, then Section 23 of the Hindu Marriage Act 1955, Section 9 of the Family Court Act 1984, Section 80, 89, and Order 23, Rule 3, Order 27, Rule 5B, and 32A of CPC, and Legal Service Authority Act 1997. Now, these are primarily all these statutory provisions which are highlighting and supporting ADR in one manner or the other, or they're promoting it. Specifically, when we talk about the statutory support which is provided by CPC, specifically under Section 89, and there have been various legislations like Salem Bar Association case, which has been the prime supporter of promoting ADR, or let's just say making a helping hand towards ADR in the court settlement. Now, Section 89 of CPC provides the resolution of disputes through various mechanisms, right? Now, resolution of disputes outside court. Now, if we look at the broader and the brighter ambit of Section 89, it is completely targeting, or not targeting, I don't think that would be the right word to use right here, but it is actually helping out courts to reduce and lessen their burden. How it is being reducing the burden? Because whenever we talk about, or there's a very famous movie dialogue, Tariq pe Tariq, and it might sound funny, but that's the reality of a legal system right now, that even if we want a speedy trial, that is not happening because of the pendency of cases. Whenever we talk about the provision of Section 89 of CPC is an attempt to bring about resolution of disputes between parties and minimize the cost and reduce the burden of the courts. Now, whenever there has been a discussion that, okay, this provision has been in existence since ages, it is not something new, but the provision was to bring about, and it is provided with the sole objective of blending judicial and non-judicial dispute resolution mechanism and bringing alternate dispute mechanism to the center of the Indian legal system. Now, the long drawn process of litigation and the cost incurred by both the parties for the same and have limited number of adjudicators have made ADR an important aspect of dispute resolution. And it is there that the judicial system is also reducing the burden and to ensure a swifter and a speedier process. Now, Section 89, as you can see it on the screen as well, has listed out certain mechanisms. Now, one by one, there has been different mechanisms through which, now let's just understand alternate dispute resolution. Yes, it is an out-of-court method, out-of-court settlement method and mechanism, but is it really helpful? The lack of awareness, which makes it something very difficult for people to accept it, right? Now, it is a process of a settlement of legal disputes without resorting to judicial process and courts. This is the basic definition, which everybody would agree. Now, these are the modes of ADR: negotiation, conciliation, arbitration, and mediation. If we talk about the codification of all these laws, arbitration and conciliation have been codified under the Arbitration and Conciliation Act 1996, whereas if we talk about negotiation and mediation, these process and these modes have not seen the light of the day, in the sense that yes, mediation is under process. And I am sure you all must be aware that the 2021 bill for mediation has been passed by the cabinet. The pre-litigation process has now become optional instead of mandatory, and there are various changes. it will be very interesting to see how this process entirely falls down, as in how it comes out after the entire process, and how beautifully it can be accepted in the society as well as the legal system, so that the most important part of having this mechanism is being utilized in its fullest sense. Now, there has been very different approach of people towards ADR. Like if we talk about, you can go through the screen and see the view of Mahatma Gandhi over it. In the concept or in the history, if we talk about, ADR has been in existence from time immemorial. Let it be panchayat system, let it be the system through wherein the matters used to be taken out to a senior person or through a king or an emperor in their locality, in their reign, wherein people would take up their disputes and the decision would be taken up by a third independent body and a non-biased person. That is how, and still, I mean, ADR as mechanism is something which we see on a daily basis. When there are two kids at home, both of them have had a fight, and they will take the matter to their mother or somebody elder in the family to resolve it. This is how it happens. So now, even Mahatma Gandhi has been supportive of this ADR mechanism, right? So now, when let's just understand one concept each by each, and then we will come down to the part that how and when it should be taught and how exactly ADR is to be taught, because it's not a theoretical paper altogether, but it's a clinical legal paper which requires a different approach other than the other papers which are being taught as a part of a curriculum to the law students. Now, I am sure you all have a basic idea about what negotiation is. I mean, if I have to give a basic example, it's like a bargain. We do it on a daily basis. Women specifically, when they go out for street shopping, somebody's getting something for 500 and you will not negotiate. You will like to negotiate on a part that let's just not buy it for 500, maybe for 300. And the final conclusion is that both the parties on their own individually talk to each other directly and come to a conclusion. So whenever in a practical life situation, if there's a dispute between two parties, this mechanism comes into picture. It does not require any third person. Now, when I say it does not require third person, this mechanism is the only mechanism which does not require any other third individual person or party to be a part of it, right? The parties to a dispute themselves can directly talk to each other, sit across a table, maybe in a closed room or in an open space, and talk about the differences and disputes and sort them out clearly. So negotiation is like a kind of a dialogue between two or more people or parties. Now, there could be more parties. It is not necessary that there are only two parties. And while talking to each other, having a dialogue, they come to a conclusion and a decision, reach an understanding, resolve the differences, and come to a conclusion that, okay, maybe you were wrong, I was wrong, and this is how conclude this entire session. Now, if we talk about how this paper is to be taught, obviously, in a theoretical class, like when I have to teach the theoretical part of this concept, I obviously tell my students that obviously this is how it happens. There are two people talking to each other, and while talking to each other, they come to a conclusion and they resolve the dispute. But when I teach them in a practical situation, they learn more in a much better manner, in a more accepted manner. I'll give you a very basic example. So I have this habit of taking practical classes as in sessions. We have model sessions for almost all the modes of ADR. In this situation, what we have done in the previous classes, and I'll urge all the fellow academicians to take up the same. I'm sure some of you might be taking it up, but it will be a quick revision and maybe an addition to what I do. So I give them real life situations, right? I give them situations that this is the situation that, for example, and we ask for role plays, wherein one party would be agitated by another party, and now you're in a real life situation. How are you going to deal with this matter? ADR cannot be taught in a mechanism like it's a theoretical part that this is done, this is how it is done, and there are parties who are resolving to dispute by talking to each other. I mean, yes, the concept would be clear, but the analogy behind it would not be clear if the students are not made to understand with the help of a real life situation. So negotiation on the whole is one of the only mechanisms of ADR under which the parties talk to each other independently without the involvement of any third party. right? Now, the next mechanism is arbitration, one of the codified version. Arbitration, according to this Arbitration Conciliation Act, is a process under which two parties submit their dispute, whether it is in existence or which may arise in future, to an independent third neutral party, and the party, after listening to both the sides, decides the matter on their behalf. And the decision given by the arbitrator is usually binding. Now, this process is the most closest to the judicial process. Why do I say that? Because in that process as well, in a court matter as well, the entire dispute is submitted to the judicial men, right? The lawyers are taking up your sides, presenting their matters in front of the judicial body, and the decision given by the judge or the jury or the bench has to be accepted. Yes, there's the provision to appeal, and the similar happens in the case of arbitration as well. Now, unlike any other mode, as in if I talk about judicial settlement, the main contract or the reason for the dispute, for example, there has been a hire purchase agreement under which one of the parties have not fulfilled their duties and obligations which they were supposed to fulfill, and their agreement says out that all the matters, let's just say all the disputes arising out of this contract will be falling under this so and so jurisdiction. So this is a dispute resolution clause in the sense that how are they going to resolve the dispute? In order to start negotiation, arbitration, mediation, conciliation, there has to be a clause added, and specifically for arbitration, I'll tell you. If there is a similar situation under which a method is mentioned, like in the main contract, it is one line is mentioned, which is known as the arbitration clause, that in case of any dispute arising in future, the matter will be resolved through arbitration, right? And both the parties have signed it. This would amount to as an arbitration clause, and that is a part of the main agreement. Now, this situation might arise prior to the happening of any kind of dispute. Whereas, if we talk about what happens that when the dispute is already arisen, it is already in existence, now what should be done? So, for in that aspect, arbitration agreement comes into picture. Arbitration agreement is an agreement under which the parties are surrendering or submitting their dispute to a particular third neutral party and stating that we want to resolve our dispute through arbitration mechanism, and both have given their consent. In order to start arbitration, there has to be an arbitration agreement or an arbitration clause, because without that, a party, or let's just say this arbitration process and this mode of dispute resolution mechanism cannot be initiated. So arbitration is a device whereby the settlement of a question which is of interest for two or more persons is interested to one or more persons, the arbitrator or arbitrators who derive their powers from a private agreement, not from the authorities of a state, and who are to proceed and decide the case on the basis of such agreement. Now, there can be more than one arbitrators. That is why it is mentioned that two or more persons. Always under the section 11 of the Arbitration Act, it stated that, sorry, section 10 of the Arbitration Act, it stated that the number of arbitrators would always be in even numbers. Or sorry, will not be in odd numbers. Why? We they said that 1, 3, 5, 7 is the terminology which is going to be used in the specific sense, because if there are going to be two arbitrators, one favors one party, other favors other party, there's not going to be any kind of dispute resolution. So there are more than one. If there has to be one arbitrator, nothing like it. Otherwise, it's going to be 1, 3, 5, and there's going to be can be endless number of arbitrators, as the Act does not specify also the limit of the number of arbitrators. The reason why we say that this is a private agreement through which the arbitrators are deriving their powers is solely because if there is no arbitration agreement, there cannot be any arbitration. And whatever kind of due roles and responsibilities which we're seeking from an arbitrator can be enlisted and mentioned in the arbitration agreement. And that is the sole document through which the arbitrators are deriving their powers. Right? Now, another mode of dispute resolution is conciliation. Conciliation is somewhat similar to arbitration in the matter that yes, it involves three people, as in both the disputant parties as well as the third person, who's obviously going to be an independent and individual person, an unbiased person who's going to help the parties to come to a conclusion. Now, whereas in case of arbitration, you're submitting your dispute to the third person, that is the arbitrator, and the decision would be given by them. In the case of conciliation, this process, yes, is involving a third person, but the third person is not going to take any decision on your behalf. The conciliator only helps to come to a conclusion, to come to a decision, but does not make it obligatory or does not force the parties to make a decision or to listen to his instructions. He's just assisting the entire process and helping you to come to a conclusion. This is the work of the conciliator, and this is how the conciliation process is. Obviously, the consent of both the parties in any mechanism is the prime most important thing, right? Now, when we talk about, when we see conciliation cases and processes, it will be wrong if we do not mention that the seriousness, or let's just say the authenticity of these processes is sometimes questioned, which is not correct, because a lot of times, a lot of parties are taking this matter seriously in their hands, and that is why they're resolving it. They want to resolve their disputes through this mechanism, right? Now, the last mode of alternate dispute resolution happens to be mediation. Now, this mode of dispute resolution also involves a third party. Now, that person is known as mediator. So in arbitration, it was called as arbitrator. In conciliation, it was known as conciliator. And in mediation, it is known as mediator. The work of arbitrator is different than that of mediator and conciliator. Arbitrator had a lot of authority in the sense that he's the person who's going to take a decision on your behalf, right? Whereas if we talk about in the case of mediation, the decision will not be taken up by the mediator, and he or she would not also be helping you or assisting you to come to a conclusion. The work of the mediator is only to act as a communication bridge and fill up the communication gap between the two parties. He's just assisting you to talk to each other and nothing else and nothing more, right? He is assisting the parties to negotiate a settlement in a very simple manner. I'll give you a very simple example. Like, for example, you have had a dispute and you still cannot look into the person's eye and talk to him. In that situation, you take the help of a third person. You may be in the presence of the third person, talk to each other. So that is why it is known as that the mediator acts as a communication bridge between the parties. And he is just assisting the parties to negotiate this settlement. Conciliator, on the other hand, help the parties to come to a conclusion. Arbitrator separately is actually giving you a conclusion, taking a decision on your behalf. And unlike these processes, arbitration is more formal in nature. I'm not saying that in mediation or negotiation are less informal, but when I say formal, because the decision which is given by the arbitrator is known as arbitration award, and that award can either be challenged or can be enforced. Now, when I say challenge, it's set aside, that because of XYZ reasons, I want to set it aside. Whereas in the case of if you want to accept it, it gets enforced. And that process also takes help with the help of the court procedure only. Right? When we talk about these four mechanisms, they are under the one umbrella and one ambit, but they're completely different from each other. The idea of having this mechanism and this mode of dispute resolution was to actually help the people to understand and make a speedy process of resolving the dispute. Because sometimes, not sometimes, majorly it happens so that till the time your court hearing you reach, the dispute is already, out of the hands, or it is not in the now not capable enough to be resolved through any kind of mechanism. But when it comes to ADR processes, it makes it easy for the people. It is more approachable. I have to take a matter to the court, and I am the person who's not able to fight my own matter. There's somebody else who's going to speak for me. Whereas let's just talk about conciliation, mediation, negotiation, and negotiation specifically. I am going to say out whatever has gone wrong according to me to the next person. And this is the most simple and less complicated process of all the modes, wherein both the parties are sitting across the table and trying to talk to each other, right? Now, difference between conciliation and mediation. Yes, it involves both. There are two people involved. That is the disputant parties, or maybe two in that. How are conciliation and mediation different? This is one of the basic questions which have been asked by the students specifically. Now, the role of mediator is not proactive. Okay. The role of the mediator over there is to make them comfortable, give them an open space, and make them talk to each other. Whereas the role of conciliator, he can probably suggest, listen, I think you can hear the other party and maybe take a call on this. Or maybe you should listen to the other party more. Or maybe, you know what, we can probably come to the conclusion later stage and let's just try to work on other parameters as well. So the conciliator has a broader work and a bigger horizon to work on, rather than if we talk about the mediator, he's just assisting and working as a communication bridge, right? Now, compromise is also there. It's an agreement or settlement of, okay. One more important part is that what happens if, okay, the process has been ended through conciliation, there has been a dispute resolved through it, what next? So whatever decision has been made out has been written down in a form of a settlement agreement. That yes, we were the parties, we had this dispute, we tried to resolve the matter through this mode and mechanism. Now the matter is ended and we have come to this conclusion and both the parties sign on it. The sole reason is that so that they do not back out or go back on their words, and it's a legal document which they've signed. And if there is any kind of, let's just say, going back or non-fulfillment, it would amount as a breach of a contract. Right? A compromise is an agreement or a settlement of a dispute that is reached by each side making concession. Both of them have fixed out that what is to be done, how it is to be done, and they come to a conclusion. Now, let's just focus on the parts for which we've basically gathered here. A major portion of the course will have to be required to be taught by examples and illustrations, and also the simulation case studies. Now, whenever we talk about, I'll tell you very basic, simple examples which we use in daily class lecture basis. Just a second. So, through the help of examples and illustrations, now you and I will simply agree. Understanding a criminal law provision with the help of an example would be little difficult because that is required, that's a set provision. But when we talk about the clinical legal papers, it requires different kind of approach. Now, when I talk about different kind of approach, I mean to say that examples and illustration, I mean, you can definitely write an IPC that would help their work there as well. And there are problem-based questions as well. But when I talk about illustrations in the mode of ADR, so the basic thing which we talk about, that what kind of agreement do you think you do in a daily basis? Is that simple thing. You're trying to a student is trying to negotiate about their pocket money with their mother or parents. This is kind of small bargain which is happening. Now, with the help of examples and illustrations, it becomes more easy for a student, and not for a student.
Yes, sir.
But for anybody.
सर पूछिए आप बताइए
और साधन का क्या
okay. I think there was some right. So under this umbrella, when we talk about the illustration or example part, it becomes very easy for a student as well as for anybody to understand the flexible approach, as well as it becomes when you pick up examples right from their classrooms, right? For example, it's a classroom of 50 people. You give them an entire situation. They have handpicked 5 students who are going to enact an entire situation and let the class decide and understand how the process actually works and flows. It will be more easy and adaptable for them to understand the entire process. Right. And at any point of time, if anybody has a question or would like to interject and add anything, I'll be more than happy to take suggestions as well. So now, through the help of examples, how do we work it? For example, I've given a situation which I recently gave to my students, was about that A and B were parties and they did not sign up an arbitration agreement, or their main contract did not specifically mention about arbitration, but can they now start an arbitration process? The simple answer to this question would be reference to section 7, wherein it is mentioned that in order to section 7 of the Arbitration Conciliation Act, that in order to initiate the arbitration, there has to be an arbitration agreement. And in the absence of an arbitration agreement, they will have to come up with the arbitration legislate, they will have to come to a conclusion, make it in writing. And it is also very interesting to know that when we talk about arbitration agreement, it just does not mean or evaluate itself to be only working around a written paper. It could also mean through an exchange of written communication, as in the exchange of letters, telecommunication, mails, telegrams, etc., wherein I am asking that would you like to resolve the dispute through arbitration, and the other person is replying to that letter. That exchange of email could also mount as an arbitration agreement. Another very interesting point about arbitration agreement is that whenever there's a statement of claim, right, and in the statement of claim, one party has mentioned that that there is an existence of arbitration agreement, and the other party in the statement of defense does not deny to its existence, this exchange and this non-denial would also mount as an arbitration agreement. These points are mentioned under section 7. So giving questions to students in the aspect of making them understand about like how illustrations work is one of the most important methods of making them understand. Another important method of making students realize the importance of practical training would be giving them or taking them to the outside real life arbitration matters. Excuse me. Real life arbitration matters happen not that frequently, but if you have you can take permission from the Arbitration Council and you can visit there. We have taken our students as well, wherein you will see real life cases, right? Most of the government matters also fall under the ambit of arbitration, where they're being resolved very easily. So real life exposure plus the practical training which you're trying to incite to the students actually helps them in understanding the ADR mechanisms. Now, also through simulation and case studies. Can anybody tell me what is simulation, or drop their answers in chat box? I'll give you a minute. Simulation, what do you understand by simulation? Anybody, if they can answer. No answers?
I think simulation is just like accommodation.
Yes, ma'am.
Just like there is some accommodation will be given to different areas of people who are living in different categories. Then that is one type of accommodation it has been given to them. May I correct, ma'am?
Ma'am, your references, I understand your point, but I'd like to slightly add more something to it. If anybody else is there, who would like to add on to what ma'am has just said? Okay, ma'am, you're somewhere correct when you say that it is like an maybe accumulation, but simulation is basically an imitative representation, right? Now, when I say about imitative repetition, I mean that representation, it's like functioning. You create, for example, what we do in our moot courts. We're providing them a real life situation wherein the students are actually fighting their own, they're presenting arguments from both the sides, from petitioner as well as the respondent. So the same kind of simulation also has to be done for ADR teaching, right? Why? Because till the time I am not in the shoes of the particular person who's facing the problem, I might not be able to understand the nitty-gritties and the issues of the problem. Now, when I say that imitation of and representation of the functioning of the system through which I am giving them a proper situation, right? I'm giving them a proper practical life exposure in the sense that I am making like in moot court, we provide them a courtroom setup. Over there, I'm providing them an arbitration setup, right? We make up a proper model session as a part of our curriculum in varieties, so that the students are able to understand the importance, and maybe also if they have any doubt in the process, that ma'am, how does it happen from there? Okay, I did not have an arbitration agreement, but the person's agitating on the fact that there was an arbitration agreement. The burden of proof obviously lies on the person who's claiming that. Now, when we talk about, we also make them draft arbitration agreements. How? Because I hope you all know that arbitration agreement. Sonal ma'am, you say that problem solving simulation, right? It is one of the modes, right? I agree with your part. Both the learned participants have mentioned it rightly. Now, when we talk about these simulation exercises or the case studies, they're slightly different, right? Simulation is a real life representation, giving them a similar courtroom case scenario, and that is how they're going to perform. I'll tell you, as a part of assessment, what we do, what I do specifically, I'll give them a problem, or maybe a one-page problem at length, under which it is mentioned that what is this dispute all about. Now, in the given situation, you will be enacting as an arbitrator, and under the shoes of the arbitrator, what decision would you be making? Right? This is one situation. Now, the another set of students are given the part that when you're not happy with the decision which is made by the arbitrator, what happens next? We try to understand and break the entire Arbitration Act into pieces. How I say, because obviously you all are aware that the Arbitration Act is divided into parts, right? So now when we talk about parts, I again chunk them down to certain portions in the sense to understand what is arbitration. Because if we take a closer look at the Arbitration Act, it does not specifically define the process. It does not specifically say that what is arbitration. It does not say what is an arbitral award. It just says that arbitral award also includes an interim award. Now, what is an interim award? So that creates a kind of a confusion in the head of the students, and that is why this practical approach has to be taken up in order to make the students understand about the complex details of process. Now, let's just break the entire act into parts, wherein we are making the students understand about the concept. Now, whenever you teach about the arbitration process specifically, you and I will definitely agree over the point that the act does not specify about a lot of things. In the sense, it does not lay down the process. I'm not talking about domestic and international. I'm talking that also Am I audible now?
Yes, ma'am.
Thank you. I'm so sorry, Gaurav. I think there's some network issue from our end. I will quickly go back to the part where we were discussing about the simulation part. Just a minute. All right. Now, as we were discussing about simulation, it is the imitation of a real world process or system over time. Also, it may be used when the real system cannot be engaged because it may not be accessible. Now, not sometimes, because most of the times it might happen that not everybody has the access to give them, maybe take our students to a real life situation where they can access the entire real life arbitration process. That is why simulation or creating a similar set of environment inside the classrooms or making a separate classroom or separate moot court hall type situation for them would be helpful, right? This helps them in understanding and how the problem would be resolved and what does actually an arbitrator do in that situation. Now, what I do in the initiation part is that I first of all give them a model session, right? That a practical aspects. We do have video sessions and recordings from the well-renowned arbitrators wherein they give a real life enacting of a situation, and then only we ask our students to take up a different matter and act as an arbitrator or a party to the dispute. Now, I'll tell you one more highlight. Whenever we are talking about not only an arbitration process, but whenever we talk about simulation situations and exercise in ADR teaching, the role only should not be given to about the arbitrator or mediator or negotiator, but also about the parties to the dispute. Because in order to give a proper decision, it is important for a student to understand the problems as well. Now, when I say that I am going to take a decision about so and so matter, but if I do not understand the main concern and the main issue of the parties to dispute, how will I be able to make a decision, right? That is why it is important for the students to understand through simulation exercises that how does it actually work and how does the role and functions of this entire process actually happen. Now, another mode which I talk about was case studies. There have been situations, there have been instances in the classrooms, I'm sure everybody would agree, wherein we give them a case law that you please study this and let us know what your opinion, or maybe write down a case summary. In management, this approach is majorly followed, case study approach, wherein a situation, real life situation, or maybe a hypothetical situation is given to the students and they have to analyze the situation and write their opinion. Similar exercises can be done in ADR teaching as well. Now, why I talk about case study method, and it is different from simulation. In simulation, there has been a real life courtroom experience or arbitration room experience for them, and therein they understand the practical part, right? Now, in the through the case study methods, a problem is being given to them and they just have to write their analogy. And by this term I say, when I use analogy, I mean is that they have to understand that how this entire dispute is working and functioning, and as an arbitrator, what will be the decision? Or the hypothetical situation could be about that this decision has been given by the arbitrator. Is it right or not? Right? Give reasoning. Right? For example, there could be a situation wherein I'll give you a very basic example. I give given this question in one of the question papers that two parties started the arbitration with two arbitrators, right? Now, one of the parties later on challenged the appointment of the arbitrators on the ground that the Arbitration Act says that there cannot be two arbitrators. Now, the question was, can this challenge be accepted since the arbitrator's appointment was done by the parties themselves? Okay. Now, as I said, that the Arbitration Act needs to be divided into various parts for them to understand that what concept is related to what part. In order to understand with the arbitration process, arbitration agreement is there. Then we talk about the arbitrator's appointment, how the appointment happens. At various levels, you will see in the Arbitration Act a lot of court intervention, or let's just say court centering approach can be there. But this process does not happen in the case of mediation or negotiation, as well as conciliation. So arbitration, that is why, is more formal in nature and slightly more complicated. But when I talk about the speedy part, all these four mechanisms are hands down more faster and a more speedier mechanism of dispute resolution than the court process, and there is no doubt about it. Now, in the another sect, if we look at the process closely, case study methods as well as simulation, as well as the not internship, but the intricate details of this process helps them to understand the basic and the minute details of the process. These approaches, which I just listed down, might sound similar, but they're very different from each other, right? I'll go back to the slide. Through examples and illustrations, simulations, and case studies, these are three different mechanisms, okay? And these three approaches would require different set of exposure as well as different kind of pedagogy. I would not deny to the part that every law or every subject can be taught with the practical approach, but sometimes it might not be possible. And sometimes it might happen that resolving the matters through or maybe understanding the concept through a practical approach is much better than any other thing. Had this not been the scenario, internships would not have been a part of the curriculum and would not have been a compulsory part of the curriculum rather, because BCI understood that through the rules of legal education that it is compulsory. Another clinical legal paper is professional ethics, right? Through the Advocates Act and Contempt of Courts Act. I mean, this could always be understood as a theoretical paper, but it is one of the most important paper of a law student's life, because we might be able to teach them laws. We might be able to teach them CPC, CRPC, contract, and whatnot. But if they're not able to understand the code of conduct and the ethics which are required by them to be accumulated and let's just say practiced while they're practicing or while they're presenting their arguments in the court, it actually fails. Nothing would matter. How much you know, but you do not know how to conduct yourself is actually failing the entire process. That is why these clinical legal papers are of utmost importance in a student's life, law student's life. Now, core mechanisms. I am not keeping Lok Adalat as a part of this pedagogy right now because of the sole reason, because it's a complete different ambit, I believe. And these four mechanisms work under the same category. Under the Lok Adalat process, no other person is required. It's like a judicial body only, which takes up a decision. But when we talk about all these four mechanisms, arbitration, mediation, conciliation, negotiation, this handles the dispute in a much more different manner. It does not involve any judicial member. Having said that, at certain points it does, but not in the manner that the court is not going to take a decision, right? For example, if we talk about arbitration, yes, if I am not able to appoint the arbitrator with the help of the other party, I might take court's help. Yes, if I am not able to accept the decision given by the arbitrator in the form of an arbitration award, I might set it aside. But the same does not happen in the conciliation process or the negotiation process, right? Court's intervention is there, and which is sometimes required as well, but it is in a very channelized manner. And I would take this moment to actually say that the court intervention sometimes might be backfired, but it is required as well, so that there is no dead end. What if the parties are not coming to any conclusion? But the question then arises that if they're not able to come to a conclusion, then what is the process of having this entire dispute resolution mechanism? So there are lot of places which require little kind of simulation, in the sense, not simulation, but little kind of different approach through which the practical problems and aspects of ADR can be taught and can be resolved. Now, I have listed out certain kind of recommended literature for all of you. I will be sharing this PPT with the organizer so that it can be sent to you and you all can have an access to it. So these are the few set of books. And this is not something which is very straitjacket that you have to refer to these books only. To each its own. And I have found certain kind of help from these books, so you can also take a reference of these. It's a list of 16 books which I have I have in my library, and you can also access it. And these books, I will again say, there might be a doubt and there might be let's just say cross question on the part that, ma'am, we're talking about the practical aspects of teaching, right? And now you're telling us the theoretical, like you're listing out the books, then it isn't that contradictory. See, the theoretical part could also be referred in the sense, why? Because these renowned authors have made it very easy for us to understand the process in a theoretical manner through this literature. You can refer to these books. Okay, now the entire objective of learning, or maybe telling the students about ADR, is to train the students to acquire suitable skill to undertake ADR at a district court level or any court level. Now, I think the word train has been preferred over teach. Why? Because we're teaching, right? We're teaching them CPC, we're teaching them contract, but ADR requires a different set of skills. A, you have to be good with your communication skills. B, you have to be a good listener. C, you have to be confident enough to actually not convince, but to tell the other people what you are thinking, in the sense of that, when I talk about negotiation specifically, if the party themselves are not clear with what they want, they'll not be able to communicate the same to this to the other party. Now, the learning objective should be of training, as in we are building future lawyers, we're building ADR enthusiasts and ADR professionals, because let's just agree that when we talk about the curriculum overall, right now, we do not teach our students extensively about the mediation, conciliation, negotiation process, right? The main focus always remain on the Arbitration Act. And the students are going to learn about this paper in their 4th years, or 7th or 8th semester, or maybe 6th semester. Till the time they've learned half of the laws, they've already studied it. In order to understand that, the training level curriculum should be set in a manner that wherein equal weightage has been given to all the portions of ADR, right? It should not be like that in out of 5 units of ADR paper, 3 units are over arbitration, and the remaining 2 units have been divided among the all 3 remaining processes. And just 2 lines of about mediation, that what is the role of mediator and qualities, does not suffice or give justice to the entire mediation process. Is definitely much more than that. And that should be included, and that should be a part of the ADR curriculum as well. Now, what are learning objectives? A learning objective describes what students should know or be able to do at the end of the course that they couldn't do before. When we entered the classroom to teach ADR, the idea is not to make them aware about the process, about the provisions of alternate dispute resolution. As in the provisions, when I say, I mean they should not be able to mug up all the sections and provisions that section 7 says this, section 32 talks about this, section 36 talks about this, 34 says this, but they should be able to understand that why this mechanisms or this approach are being taken up by people and how is it helping them, right? To decide learning objective, one has to begin with the end in the mind. This is the prime objective, I believe. If I am not sure right now, like just say before, if you're attending this session, if you do not have this objective in your mind that you're going to learn something new today, the approach, or let's just say the reason for sitting in this lecture or listening to me would fail. You should have an objective, and you should have an objective in the sense that you should know how you're going to end this session. So one has to begin with the end in mind, then only they can reach a learning objective. Something like end would decide what means to be followed. Now, if I know what I'm going to learn today, I know how it can be implemented. That is why it is important to have the learning objective in the mind. Evaluation is also one of the part, because to be carried out in practical exercises, at least for a significant part of evaluation. When we talk about simulation and everything, how do you judge then if, okay, how they have enacted this entire situation? Evaluation of the performance is one of the prime criteria through which you'll be able to understand whether the student whether all the students or your cohort is actually able to adapt what you were trying to teach them, or what was the main motive, right? Now, I would conclude here by telling that ADR teaching and practice should involve an innovative approach by the faculty as well as the formulated course for internship. And clinical teaching may be utilized as one of the major modes for teaching in law schools and for suitable imparting of professional skills. Now, whatever simulation or not simulation, whatever discussion we have had or whatever I have said in the past, like more than 60, 70 minutes, this happens to be the approach which I have followed. This is not a straitjacket formula. This is not something which is hard and fast. I am sure a lot of you might have different approaches, might have had different kind of experiences, and I'll be happy to receive any kind of comments or feedback or any questions which are there from your side in order to make my approach also better. And let's just have a discussion about whatever you have any doubts about, so that we can also learn something new today. On that note, thank you so much. Gaurav sir, if there are any questions, I'd love to take them up.
Any of the participants have any questions regarding this session? They can just unmute themselves and ask their questions. Anyone who has a question, they can just unmute themselves and have the question before the panel.
If there are no questions, I believe people have agreed to what I have said. So you can give your feedback as well if there is any kind of change which you would like to suggest. I'll also be happy to hear that.
I guess, ma'am, you have satisfied all the participants with your session, and there are no more questions from the participants. So a very thank you for being a part of this refresher course and giving an insight on the topic which you took for this 15 days online refresher course. And thank you so much, ma'am, on behalf of Droid Penal Group, Barkatullah University, and Guru Angad Dev Teaching Learning Center.
Thank you so much, Gaurav sir, for inviting me and providing this opportunity. It's always good to interact with academicians. It's always a great opportunity to have a discussion like this. Thank you for this opportunity. Thank you.
Thank you. For the participants, I would like to inform you that the second session today will start at 5:30 because there has been some internet connection as well as some problem with the resource person. So he will be joining at 5:30. So we'll just join this. We'll restart the session at 5:15.